Hello, everyone, and welcome to today's episode on cross border investigations and dawn raids, managing risk in a multi regulatory enforcement landscape. As enforcement actions become increasingly global, companies today are no longer dealing with a single regulator or a single jurisdiction. Instead, they're navigating parallel investigations, that is, multiple regulators in different countries investigating the same issue at the same time, along with dawn raids, which are unannounced inspections conducted by authorities, typically at a company's premises to gather evidence. What makes this landscape particularly complex is it is not just the legal risk, but the operational, strategic, and reputational challenges also that are attached with it. So I'm delighted to be joined by two experts in this space today. We have Ms. Ojasvita Srivastava. She's General Counsel and Risk Manager, Africa, Middle East, and Asia Pacific at Securitas Group. And Ms. Natasha Treasurywala. She's partner at Desai and Diwanji. Thank you both for joining us today. So starting with my first question to Natasha. My first question is in parallel cross border investigations where multiple regulators are simultaneously examining the same conduct across jurisdictions, what breaks down first? Is it legal strategy, internal coordination, or leadership decision making?
I think in my view, it would be internal coordination because legal strategy or, leadership decision making is something that, can be, designed centrally. There can be, uh, policies put in place from the get-go. But as far as internal coordination is concerned, that is the key. And if there is not a coordinated efforts between different jurisdictions, then you're going to be in, there's going to be serious trouble because you have to be on the same page across jurisdictions. So for example, if your African counterpart is going to say something different from your US counterpart, it's going to have a huge impact. So it's very important to have that internal coordination in place. The legal strategy, etc., can follow, right? So you need to get counsel on board. You need to get, the business teams on board. Everybody needs to be on the same page, have the same strategy. So without the coordination, that's going to not happen, and then it's going to be a failed effort, and the outcome is not going to be good.
That's interesting because it also raises the question of how prepared companies actually are before a crisis even begins, how internal coordination is important. Coming to my second question to Ojasvita, are companies truly prepared for dawn raids today, these surprise regulatory inspections, or are they still relying on outdated checklist-driven compliance frameworks today?
So, Avni, on paper, I would say yes, a lot of companies are prepared today because most companies have a policy. They have, contacts lists in place. They have probably a flow chart, what should be done when, etc., etc. But in reality, this is not necessarily always the case. Because when it comes to raids, when it comes to dawn raids, it's not just a paper policy. It's more about how in practice people are, how prepared they are, whether people should know how to act under pressure. And, a simple example would be if you have a dawn raid, does your front desk know what to do without having to call 4 or 5 people and knowing how to respond to a situation like this? Are people, in practice of knowing what needs to be done? Does IT know what to share and also what not to share? Does, for example, management know, what is being helpful and what is acting as if you are not cooperating with the authorities? And what Natasha said, for example, that coordination bit, the legal, the communication team, the management team, HR, IT, all of them need to be able to work together. And only when that is the situation, a legal can actually act as, as a response to a dawn raid. Otherwise, you would just end up firefighting because the IT has shared something that they should not. And what you have shared in one country might end up, harming the other country. So it's more a capability that needs to be developed and not just a document. And I think that's where you would really say that a company is prepared for a dawn raid.
Okay, so are trainings also part of it beforehand if such situation arises?
Absolutely. You have to have a training. You need to have, so there are three-step process. Basically, one is you need to have your policy in place, a document that defines what needs to be done when. Secondly, you need to do a training to everybody involved who is supposed to respond. They should know that they should expect that something like this can happen and what they need to do. And then you also need to, very importantly, do test runs. You need to have a scenario where you have tested this and seen that it works. And we do this as well, as tests of, say, business continuity plans and things like that, and not just dawn rates. But in general, unless you do all these three steps, you can't be sure that you're prepared for one.
But having said that, I think, Ojasvita, the point is that you can never be fully prepared. You can only try your, utmost best to be prepared, and that's what trainings, etc., do. But people come, people go, so trainings also can only go that far. So I agree with you in terms of, policies, paper, everything is great to have, but it's only when the actual, the thing happens is when everybody scrambles to come up with a solution. And that's when, everybody has to be on the same page.
100%. Completely agree with you. And what we can do on our end or on our part is to prepare ourselves for as many scenarios that we can imagine and think. Nobody knew there was going to be a COVID, so nobody knew how to prepare for borders shutting down and people not being able to move and things like that. But there are things that you can prepare for, because we know that there will be, not sure when, but there will be a cyber attack. So you know how to prepare for a cyber attack. You know there could be a dawn raid by a labor commissioner. So you need to prepare for that. So that's, the best that we can do. But of course, you never know what can happen.
Correct. Yeah.
Scenario planning can definitely help the companies a lot. Coming to the next question to you, Natasha. How can organizations navigate conflicting legal privilege standards, given that different jurisdictions recognize confidentiality protections differently, while balancing cooperation with regulators and protecting their own legal and commercial interests?
So I think the legal privilege question is it's something that's very important in these matters. And we've had a recent judgment of the Supreme Court in India also, which dealt with this issue, which said that, privilege does not always apply to in-house counsel. So that's something that was a bit of a, it set us back a bit in terms of jurisprudence. So EU also has similar sort of, it doesn't always recognize in-house counsel privilege, whereas the US does. So the point is, in different jurisdictions is treated differently. So the best way is obviously to treat it with the highest level of, the restriction, which is that it is restricted. It is not applicable to in-house counsel. That's what you should go with probably. And as a result, the best way is to, have an external counsel, have things go through the external counsel. So at no point in time is there a, issue with privilege being, disturbed in the sense of because external counsel is always protected. So that privilege is always there across jurisdictions. So it is more about in-house and how in-house has to be very careful. And just generally, people in the organization, in the system need to know that just because mails have gone to the in-house legal, it is not privileged and confidential necessarily. So you have to be very careful in this regard.
Thank you for sharing that. Coming to my next question, Ojasvita, around data sharing. So, in cross-border investigations, is data sharing including transferring emails, documents, internal communications across borders, more of a legal or strategic? Is it more of a legal or strategic challenge? And where do companies most often go wrong with that?
So before I answer your question, Navani, I want to make a point or just comment on what Natasha said. In-house lawyers in India never had privilege. What Supreme Court clarified was only reiterating what is already very well known. The Advocates Act is very clear. As an in-house lawyer, when you start working, you have to suspend your license, and therefore there is definitely no privilege. And that is the case in many countries as well. Sweden, for example, in-house lawyers don't have privilege. In Australia, limited amount of privilege is there depending on what kind of work you do. So I think if there are some in-house lawyers who were not aware, then Supreme Court helped them to understand that. But that was never the case. I don't think any in-house lawyer in India would advise their management that they have privilege because they have included the in-house lawyer. Coming to your question on, cross-border data transfer, whether that is a strategic or a legal decision, it's 100% a strategic decision, without a doubt. And I think one has to look at it that way in order to prepare, because when the dawn raid happens, you need to be careful about three things, in my opinion. One is you need to have a very good coordination, like Natasha said, right? You need to have a coordination among the teams. Secondly, you need to know the proportionality. What is being asked and what amount of information you are giving, that needs to be there. And thirdly, you need to have control. So, for example, there shouldn't be, treating of data as a simple yes or no decision. There needs to be an understanding of what a decision of sharing information in one country would have an effect in another country. For example, if you have a data breach in a data center where you have information or data from multiple jurisdictions, some of these jurisdictions, the authorities, the data authority will have a requirement to report it to them within 48 hours, for example, in India. Similarly, they would have a requirement to also report it to the principal whose data has been affected and things like that, right? So those are statutory requirements. But when it is an authority that is coming in and investigating, you actually have the privilege, or you have the authority, the option to decide how much of that is relevant for that particular authority or not. So you don't need to disclose everything. And then also another challenge, or I think the other pitfall that a lot of companies go for, is that they start putting in, assuming that there is privilege that travels across different jurisdictions. So for example, if a certain information is privileged in one country, not necessarily that it is privileged in another country. So if you are forwarding information that is privileged in one country, you need to have control. You need to make sure that you only forward it, the information that is actually relevant for that particular authority. Another thing I think that people start looking at is, or start, making a mistake of, is to start losing control on what kind of scope of data is moving out. That also is very important. It has to be limited to the scope of what exactly needs to be transferred, what exactly is requested by the authorities in the dawn raid, and not share or not overshare than what is actually required.
Okay. Thank you so much for sharing that, Ojasvita. Coming to my next question, and as Natasha, you said in your first question, you talked about how important internal coordination is. Is it better to adopt a centralized global investigation strategy where decisions are coordinated from a single headquarters, or should companies decentralize and localize responses jurisdiction by jurisdiction?
Yeah. So, Avni, before that, just to again, Ojasvita, on your point on the privilege, yeah, I agree completely that it wasn't applicable even earlier. But I just think that something that perhaps a lot of general counsel, especially, would have liked to see is that, if the Supreme Court didn't sort of, I mean, they just upheld what was in the Advocates Act at the end of the day. But I think going forward, obviously, it would be easier for everyone if that privilege could be upheld. Like in the US, it is extremely, it's completely, there's sanctity in the privileged, and it's confidential information between. But you're right, it's not something that's, new. It's always been that way. Just
But
that
that's
I
a
don't
very
know if others, but the thing is that while you and I and all the lawyers and in-house are external are all aware of it, it's not necessarily that all employees may be aware of it, because they may think that, if you have a GC, they're going to be, it's completely privileged and it's not going to get out. You and I know that the extra, you will have to give up your bar council card license, whatever, but not everybody
And I
knows
think
that,
that's where the role of a responsible general counsel is. They need to apprise their
Yeah,
management
correct.
that this privilege exists or doesn't exist.
Absolutely. Yeah, I agree. Yeah. So, Avni, to answer your question, I think centralized global strategy. So, yeah, I think it's not that you can just have, one central strategy and then apply it across all jurisdictions, right? There can be a, broad framework, But ultimately, it has to be jurisdiction specific also. Like Ojasvita said, even in relation to privilege, right? It was something privileged in one country may not be so in the other. So while you may have a centralized strategy in place, it has to balance in terms of the actual, local execution, because, the regulatory expectations are different, legal framework is different, even cultural dynamics are different from country to country, right? So it has to be a little catered to the local jurisdiction. So you can have a larger framework, a broader framework, but locally you have to also have certain things in place.
Sure, sure. And just building on to that question, because of different jurisdiction, there are also multi-regulatory enforcement trends. And to you, Ojasvita, where several regulators are pursuing the same issue, uh, does this often also creates compliant burdens for the businesses, or like how the global cooperation gets developed when there are multi-regulatory enforcements and different kind of regulations being involved in one particular investigation?
Yeah, so I think it creates disproportionate compliance burdens for the business, depending on multiple jurisdictions' requirements. What exactly do they need? It's never going to be like the same response. Like what Natasha said, depending on what is the requirement under your local law, your response to it, your compliance requirements would differ. Though I do believe that there should be an enterprise level strategic overview on how you handle these different risks and different responsibility compliance requirements under different countries. Because if you don't have that, then that's what, to the previous question that you had asked, we will have issues when there are multiple regulatory authorities investigating or becoming a part to the same event. So, and also from a workload point of view, if I look at it very practically as a general counsel, multiple regulators will be asking you for the same facts on different timelines and on different rules. So it's the exact same facts that you're probably providing, but the details and everything are exactly the same, but they will be asking for, under a different law, under a different local law in different countries. And then it becomes very important to make sure what is privileged, what is not privileged, what is allowed in one country, what is not allowed in country, etc., etc. So, it is not just a question of are we compliant in that particular jurisdiction? It is a question then of what is the sequence of disclosure? How do you manage the scope? How do you engage different regulators without multiplying your risk? Some countries, if you take the same example of, say, a data breach, some countries would have a timeline requirement within which you need to inform a authority. Some countries don't. Some countries only have a requirement to inform, but there is no following investigation. Some countries have, as soon as you inform, the regulator is going to come and investigate into you. So there are multiple consequences of that. And that's the reason why you need to have an enterprise level strategic overview also, so that your coordination, your judgment, your ownership, everything is sitting at the top, and it is not left to the countries or not left to the particular jurisdictions. And so if it is only left to the countries, they just simply have a policy and they follow that policy. But that's not how it is best handled. I think it is more the strategy that is important and not just a policy.
Thank you, Jaswita. Now, zooming a little bit into Southeast Asia, coming to you, Natasha. Are you seeing increased coordination between competition authorities and regulators that oversee anti-competitive practices in jurisdictions like Singapore and Indonesia during these cross-border dawn raids? And how is this changing the way companies structure internal investigations and their data governance frameworks?
Yeah, so I think there's definitely more coordination. I mean, even we get asked by clients, that whether if the Competition Commission has an issue, if will there be a data sharing between Competition Commission of India if there is an issue in India and another regulator outside of India and another jurisdiction. And there have been cases we have seen where the regulators are sort of, they do share information now. There is more of a joint effort. But at the same time, we've not seen where, like in the EU, it's quite common, but in it, we've not seen where, both there's joint sort of raids happening at the same time. They may be parallel in some terms of, if the Competition Commission has found something here, then maybe in Singapore also there might be something that, has triggered, because it's triggered from the Indian CCI and has gone to Singapore. But it's not that they all, they decide together that we will together, go at 5 a.m. tomorrow and, go and do a dawn raid on this company in Singapore, in Africa, and in India. That is something that we have not seen as such in as much in the Asian countries. But definitely there is definitely more coordinated, sequenced investigations and coordinated enforcement, etc. Which is why it's so important that companies, invest also in data governance, as to where's the data, what is the privileged material, so that if this is privileged, you have that organization of the data, because that's also very important, especially if things are going to be shared with other regulators, then you have to be very careful of what is being, sent to whom, etc. So it's very important for companies now to be even more sort of careful on what data, where it is stored, and related issues.
Sure. Thank you. Hi, Ojasvita. So my next question is to you. As you head the Africa, Middle East, and APAC region, how are multinational companies balancing immediate dawn rate response with longer term reputational and compliance risks, especially when investigations run parallel in multiple jurisdictions?
So, yeah, I think like I said earlier, it has to be a concerted enterprise level strategic overview in how we handle multi-jurisdictional dawn raids or investigations. Right? There could be multiple jurisdictions that have similar sort of parallel investigations running, and there could be a situation where we have one investigative authority that starts an investigation and something comes out of it, like Natasha said, and that triggers an investigation in another country. So therefore, there has to be a very concerted, discussion, coordination, and decision before, how we handle this. Earlier, when we talked about dawn raids, a lot of companies, a lot of organizations, even us GCs, we used to be worried about when it happens on day one. How are we going to react to it? How are we going to manage it, etc., etc. And I think as a result of that day one focus, people used to lose sight of the long term impact, or because there are a lot of investigations that could be multi days. And also, whatever is found in this investigation can have long term impact, reputational effects, not just, effects or consequences under the law. So, from that perspective, also, there needs to be a very concerted coordination between legal, communication, compliance, and management teams. And there has to be a very coordinated effort on how we flow the data, what data is flown. Again, I'm repeating myself, but what amount of data is, provided to the authorities? How exactly do we make sure that because of information that we are providing in one country, we don't become non-compliant in another country, right? Because there could be reputational damages. What may be totally normal and acceptable in one country may not necessarily be acceptable in another country, right? Especially in companies like ours, where we have so much of, say, labor that moves across countries, or that has a very labor-intensive, way of working. So maybe the kind of facilities, etc., that you provide to labor in one country may not necessarily be very acceptable in another. So there has to be, a very concerted effort, very early coordination between all the team. There has to be discipline in how we share data and how we message. And there also has to be a constant awareness within the team, within the organization, on how regulators work, what are their moves, how exactly do they coordinate with each other across countries.
Thank you. And moving on to the last question now, as both you talked about the dawn rates till now and their importance and how they can, be helpful in uncovering the truth and ensuring fair enforcement. But do you also feel that they sometimes, they have become like a pressure tactic that forces companies into early cooperation, sometimes at the cost of their legal rights? To both of you.
Yeah, of course, it is a pressure tactic. There's no doubt about that. But then it's also I mean, it's both ways, right? There is always an element of surprise, and that is the whole point also of a raid in general, right? You want to catch somebody by surprise so that they're not prepared. If they're prepared and they've hidden away whatever they need to hide or whatever it may be, then you're obviously the whole point is vitiated. So it's important also from the regulator's point of view. I can completely see why they would want to do it. From a client's perspective, or perhaps, a company's perspective, if the company is in the wrong, of course, then obviously it's something that is not going to, it's going to be, not in the best, not the best for that company. But if you're in the right, and if there's nothing that you have done wrong, then, it's fine. I mean, the regulator wants to have that element of surprise and not give you that time. So I think it's a legitimate tool at the end of the day that regulators use. If it's but yes, pressure, of course it is pressure. It is pressure, but if you are in the right, then I think there's nothing to worry about. It's just how you handle it, right? Because there's so much pressure that, there may be missteps, things may be said which, should not have been said, which may not necessarily be because something's done wrong, but it's not, it could be misconstrued. And when there's pressure, people do tend to do things in a hurry. So it is a double-edged sword, no doubt. But that's the nature of it, I think, at the end of the day.
Very true. And from my perspective, I would probably split this answer in two. On whether or not this is a pressure tactic. As a general counsel, when I'm talking to my team or my organization, I would steer away from that question. It is, like Natasha said, a legitimate use of power. So you cannot prevent an authority, and you cannot try to get away or try to get any leniency by saying that this is a pressure tactic. It does not work. So the best we can do as an organization is to prepare for it and make sure that we have our books in order, we have everything by the rule. So that is on the first aspect. And the second aspect, I think, as an organization, you need to be well prepared. You need to make sure that you are not seen as non-cooperative, and you are also not digging your own grave, in the sense that if you cooperate too quickly, too easily, then you are probably going to waive away some rights, some privileges that you should have said up front. If you've given away all the information, that may not necessarily be the right course of action for the organization. On the other hand, if you keep pushing back and if you don't cooperate also, then you are being, bracketed under being non-cooperative. So as an organization, again, the policy, the training, the practice, the test runs, all of that need to be done on an annual basis, at least, to make sure that everybody is well prepared. And if there are a legitimate right of power by an organization, all you can do as by an authority, as an organization, all you can do is to prepare.
Thank you so much, both of you. I think this will be incredibly insightful, especially for the corporates who will be listening to this discussion. And thank you so much, Ojasvita and Natasha, for coming to this panel and joining us.
Thank you. Thank you so much.
Thank you for having me, Abhini. Thanks a lot.